Welcome to our virtual live. This is where we can record and present it as a podcast later on. We do it with an audience live on Zoom so we can get more questions than what I know to ask. And it looks like I have got some experts on the participant list that have some great questions. I want to welcome Bud Whisler, Walt Whisler. Which do we call you? I need to know that first.
Bud.
Bud. Okay. On Facebook, you're Walt.
I didn't realize when I was first signing up for it, I didn't realize the difference. And so I just put Walt in there, but I'm Bud.
Okay. Well, we will stick with Bud, and you are with Advantage Title.
Yep.
And I know you have been working with real estate investors ever since I have ever met you. We've had some complicated deals that I know have gone across your desk. So you are probably a veteran expert on everything that can go right and everything that could go wrong in contract for deed.
Over 40 years in the business.
What is Advantage Title and what do you do there?
At Advantage Title, I'm one of the owners and I run the operations. I've got office up in St. Joe, and then down in Brookside area down there, and then one out in Blue Springs. And that's a small agency by design. I didn't want it to get big and huge. I've been there, done that. I used to run a very large underwriters operations here in the Midwest, covered 11 states. And I've been through downsizing from 250 employees, taking them down. And I just swore this time that I wasn't going to go through that again. So I've just consciously kept my staff small, kept our business small, because I just don't want to go through that. I just don't want to do it. And I wasn't going to every deal there was out there. I don't have a wide variety of customers, but the ones I have, I like and I take care of them.
Well, that's good. First up, what is contract for deed? When somebody asks you what's a contract for deed, what would you tell them?
Well, I'm going to dissemble a little bit here, and I will discuss contract for deed, but title insurance is a misnomer. We're not an insurance company in the classic sense of the word. We don't look at risk and assign a dollar value to it. We are a risk elimination company, or an industry. We eliminate risk because insurance, traditional insurance, you pay a premium every year. In our industry, you only pay one premium. That's it. And that lasts a lifetime that the insurer still owns the property, either the owner or the mortgage lender. That loan's still in place, still gets paid off. That insurance goes, it can go for 30 years. And so we have that liability. We eliminate risk. That sometimes might explain why sometimes you see a title company going, well, that's awful minor, that's awful petty. Well, those of you who have been in the business long enough know most lawyers, when you call them and say, I got a problem, it's a $2,500, $3,000 retainer fee up front. So as you can see, it doesn't take much for us to end up losing money on a deal. So that's why we try to focus on eliminating risk. Here's a little known secret. The title insurance underwriters don't insure against escrow matters. That's what our E&O policies are for, is take care of escrow losses. There's a difference on a title claim and there's an escrow loss. And those two don't get mixed up. But title insurance itself came about in the late 1800s out of Pennsylvania. And the reason being was prior to that time, I don't know if you've been in the business long enough, but some of you may have heard the word abstract. They're still used up in Iowa. If you bought a property up in Iowa, abstract. You bought a property down in Oklahoma, there's abstracts down there as well. And
Paola, Kansas, when I was growing up, abstract.
Okay. And so back in the day, title insurance came about because if something went wrong, you went to a lawyer and you sued somebody, and the lawyer might not have any money to pay it. So title insurance came about as a result of that, to provide a contract of indemnity. And that's where the basis for contracts for deeds came from. They're called land contracts. Back in the day, there wasn't a bank with a drive-through on every corner. Banks were few and far between. A land contract is an agreement to sell between a seller and a buyer. It's essentially a financing vehicle. The banks weren't around, but you could go to the local abstract office and have a lawyer fill out a contract for you, a land contract, and you agreed to pay so much for a piece of property at principal and interest. And then at the end of that term, the owner of the property would execute a deed conveying property to you. And so it was a financing vehicle, and there weren't the vehicles like there are nowadays. So that's how we get to the word land contract. And they were prevalent even here in the Kansas City area, and they're still prevalent in a lot of areas. back into the middle late 1900s. When I got in the business back in 73, we still had a lot of contract for deeds, and they were often held by a small title agent who would have fireproof safe, and they would hold them in there for security purposes. So they wouldn't get burned up, because usually the deed was executed and it was held by that title agent in their safes.
They were making sure everybody was doing what they were supposed to do.
Yes.
They're keeping everybody honest.
Yes, so-called neutral, disinterested third party. So that's where the term land contract or contract for deed came out of. It came out of that. Like I said, I'm not a lawyer, so I'm just giving you the dumb old redneck version, okay?
Okay.
So that's where it came out of. And it's a financing vehicle. And most often back in the day, it was because there wasn't any place to finance. But nowadays it's used for people who oftentimes maybe have bad credit, can't go through the traditional lending methodologies and qualify for a loan. Credit ratings might be really bad, or they might have enough stated income. And you all know much better than I do what the reasons are why somebody might want to use them.
Well, I know that a lot of the land contracts are used on mobile homes because a lot of banks don't like to lend on mobile homes, and on properties that are under the dollar amounts that banks don't want to lend on. So the banks aren't redlining against certain areas of the city, but they just say, I'm not lending to anybody or a loan amount under, say, $80,000. So how does that person buy a house if the bank's not going to lend money? Well, either we got to sell or finance them, or we do a contract for deed. And it just depends on the area. I think I see it a lot more in Texas than we do here in Kansas City, but I do know they happen here in Kansas City.
Yeah, and I'm doing some reading and digging. In states where there's a large Latino population, they're comfortable with that type of purchase because land contracts are used quite a bit in Mexico. So it's not something that's unknown to them. They feel comfortable with it. But here again, you said something about owner finance. Well, using a contract for deed, you are in essence owner financing a property.
Right. It's just a different type of vehicle.
Right. But nowadays, a contract for deed is being used in a different way with a different purpose, and in regards to due on sale provisions. And so that's a very gray area right now.
So they're using that to get around the due on sale clause. If they don't transfer title, they don't trigger the due on sale clause, they probably believe, I would guess.
And in fact, I was just looking through as a preparation for this. They've actually inserted language in the new Fannie Mae loan documents, specifically points out contract for deed.
So you can't do it?
Well, no, it says that as an example of ways to trigger the due on sale. It didn't used to mention contract for deed, but transferring an interest, the equitable interest in the property to somebody else. And they mentioned trust and they mentioned contract for deeds, which was kind of surprising to me. It didn't come up, and I don't recall seeing it in years past. I just closed the deal and I was looking at the language, back in their deed of trust. It was a Fannie Mae deed of trust, and there it was right there. Because I know some places they talk about doing land trust and, actual trust, and then conveying the trust from one party to another as a way of mitigating, I'll just say it, avoiding the due on sale provision. And they popped it right out, and it was right there, and it really surprised me. It surprised me to see that.
So I know when we do a traditional seller finance, like the bank does, we have a promissory note, and then we're either going to have a deed of trust or a mortgage that's going to be recorded at the recorder of deeds office that say whatever it says. But when we do a contract for deed, what kind of form do we need with a contract for deed? What do you see when they're closing those?
If someone were to ask me, I would suggest using a memorandum, putting the public on notice. And in Kansas, if you file a contract for deed in Kansas, it's treated as a mortgage, which means you have to go through a mortgage foreclosure process. In Missouri, it's a little bit different, but if you file that memorandum, and that puts the public on notice that there's an unrecorded contract for deed out there. I don't recommend recording the contract for deed. Some people do, I don't.
Okay. I know this came up, I don't remember when it was. Somebody was trying to get a law in the state of Missouri to model contract for deeds in Missouri after the state of Texas, which, so I understand, is really, really bad. So you're just filing a memorandum, not necessarily the contract for deed, but you can file the contract for deed documentation as well to put the public on notice, correct?
Yeah, absolutely. You certainly can. It used to be a practice back in the day They used to actually file a contract for deeds. Now they don't. They just file a memorandum out there.
Okay, and then you hold that contract for deed as your paper. Is that, I know in the seller finance world, that promissory note is the end all be all, and you don't want to lose that original promissory note. I guess they're probably getting better at having scanned documents, but you need to keep your original contract for deed.
Absolutely. And that contract for deed, we use the term interchangeably. Some people use the word note, and it's not a note. It is a contract for deed. It may have financing terms in there that are more specific than a note itself, but it's an actual contract for deed. And in my world, as Michelle has heard me oftentimes say, words have meaning. And so I'll fuss at her sometimes when she uses one word, I'll go, no, and we'll stop because, like I said, specific words have specific meanings in the context of real estate, from my perspective anyway. And so if it's a contract for deed, it's a contract for deed. But you are absolutely correct. If you sell the contract for deed, you need to assign that. But one of the key elements is you need to make sure that that contract is assignable. I have saw some where it wasn't assignable without approval. And so you just get caught up in all kinds of things. And again, as some have heard me say, you're always bound by the four corners of that document. Whatever's inside those four corners drives the process.
So if we're going to do a contract for deed, we probably want to work with an attorney to draw up our terms and put in all our what ifs so that we have all of the bases covered within that document, correct?
I would agree. And as you know, Kim, you can go out to Google and there's 9 million contract for deed forms that you can download and use. I would recommend it. If this is going to be a practice for you, it's going to be a habit, and it's a tool in your toolbox you want to use, I would just suggest that you go ahead and spend the money to have a lawyer draft it. That way it's drafted, in your construct, because as you know, and I know you've been to court and I know Michelle has too, the document is always construed against the drafter. So if you don't have your terms in there that you need or that you want, it's going to be held against you. And so I would just suggest spending the money. That way it's there. That way, you've got it and you got somebody you can fall back on if something goes south.
Well, we keep referencing Michelle, and I think everybody on the call knows who Michelle is, but I was going to say, Michelle, would you say hi? I'd like to learn, who is Michelle?
Michelle Winberry. I do not have my camera available tonight. Sorry. Run Winvestors. I'm a realtor. I'm a member of Mary, and I work with Bud a lot.
And you do a lot of notes, and I bet you see in the note world, I know you and I both started in the note world about the same time, and I was amazed how the contract for deed was referenced as a note. Just, they didn't really make a difference between the two, at least what I saw.
Well, it's the same concept. It's the financing behind the real estate. It's just a different way of doing it. Like transportation, you fly in an airplane or you ride in a bus. It's two different things getting the same basic thing to do.
And I have to admit, I have learned something here in the last few weeks that I had no concept of. And in the note world, much like when you're selling the contract for deeds, it exists in the same world. The rules that you sell to a servicer are a whole lot different. I was surprised. That's all I'll say. At the documentation and what you guys have to worry about and have to deal with the servicing entity, the goodbye and hello letters and everything else, I was really surprised.
Yeah, and the terms are similar. And I think that's where sometimes we forget when we're talking about RESPA from a note standpoint versus RESPA from a different standpoint. It can be very confusing for people to understand. You've got your hello letters, you've got your goodbye letters, you've got to follow all these rules, which is totally different than just wholesaling or selling a piece of real estate. And in contract for deed, it's more complex because contract for deed has the note world rules as well as real estate rules, because they're selling the property subject to the financial contract or the financial agreement.
So if you have sold a house on contract for deed to Bud, but you want to sell me the house in the note, you could, and Bud couldn't really do anything about it. As long as that's what your contract said. You could sell that to me and then Bud would have to pay me instead of you.
Correct.
just a couple of different things that I saw kind of popping up here. There's the contract for deed itself. All right, which it's a contractual agreement between parties that if you pay me X number of dollars on time, every time, then I'm going, at the time this contract is paid off, the mortgage is paid, for lack of a better word, then I'm going to give you the warranty deed. And by the by, just to make sure you feel safe, I'm going to execute the warranty deed right now and put that in escrow. And by the by, if you don't cooperate with me, and if I have to try and get you out because you've failed to full terms of the contract, I'm going to give the buyer's going to give a quick claim deed back.
So,
Well, there's a whole lot of problems in that. Number one,
Bud, let me stop you there for a second because you did kind of get stuck there. So what he's saying is when some people put their contract for deed together at the beginning of the whole term to satisfy the buyer's concern that they're not going to get the deed, the seller signs a warranty deed over to the buyer and holds that in escrow. But the seller, they want to protect their interest. So if the borrower doesn't pay, the buyer doesn't pay, they're getting the buyer to sign a quick claim deed back to them at the beginning that's also held in escrow so that they can get the house back without going through all the rigmarole of what the losses are supposed to do.
I'm sorry, you're absolutely correct. Let's just touch base for a couple points. Why would somebody want to sell under a contract for deed? Because you still own the property, correct? You're still liable for the property. In your world, who do you believe needs to keep the property insured as to property insurance and liability? Is it treated like the contract vendee, the buyer? Can they only get renter's insurance, whereas you can get an owner's insurance policy protects you? I mean, who's going to deal with all that? I don't know the answer.
I'm in that situation with the property right now. I'm carrying insurance, but I don't know if the borrower is carrying insurance. We're finding that out. But even if they are carrying insurance, I own the property. It's in my name, but they live there and they're treating it like it's their house. So even if they are paying for insurance, I don't know if their insurance would pay if something happened. So who knows? That's a good question for our insurance people and my insurance call I'm working on.
I don't know the answer to those questions. You guys have to figure that out. You're subject to the whims of the buyer. What happens if they tear the property up and they just walk away from you? You're not going to be able to just walk in. I don't know if you can take them to landlord court. Maybe you can't. I don't know the answer to that. Most of the times I saw they have to go to court and extinguish the person's rights in a court proceeding. So I don't know the answer to that from an actual practical standpoint.
I was talking to somebody that deals with this issue, trying to get the tenants out. And one of our speakers at Marion, when we talked about this a few months ago, said they were going the whole contract for deed route so that if the borrower didn't pay, they could just evict them. And a few of us brought up the fact that the buyer has put down a substantial down payment and made payments. And in the state of Missouri, and I'm pretty sure in the state of Kansas, you can't just evict them. You have to foreclose on them. But it's not as simple. So if you're going to foreclose on a property in the state of Missouri on some mortgage and a deed of trust, that takes what? It's a 21-day state. So in theory, 21 days. It probably takes more like 3 months, I would think. I would say 3 months to foreclose. But when you're foreclosing on a contract for deed, how do you do that? There's no foreclosure language in the contract for deed. So it's up to the judge to decide how you do that.
The operative word is judge. It's a judicial proceeding. And then you're at the whims of the court, getting them served, getting it docketed, and then getting them into court. It's not an easy process.
I was talking to someone that said they were trying to foreclose on a contract for deed tenant, and it was up to the judge to make up the law as he went along. And it took over a year and a half to foreclose on the property from a contract for deed position. But if they would have had a mortgage in it or a promissory note and a deed of trust, because it was in Missouri, they could have foreclosed and had the house back in 3 months.
Well, it's a little bit more than that. 30, you have to make a demand under your deed of trust term. You declare them in default, give them 30 days to cure. Although a conveyance without loan approval, without borrower approval, they may not allow you to reinstate that loan, which means it goes 30 days, demand, pay it off. And if you don't get it paid off, the 20 days, 21st day, they're calling a sale on the courthouse steps.
Michelle has a question. What are the rules regarding recording that quitclaim so you talked about having that quitclaim deed from the borrower back to the originally owner of the house from day one. So if you tried to record that, are they going to be able to do that?
Well, they can record it, but the question is going to be, does it have any validity? How many times have you looked on a deed and it says $10 and other the good and valuable consideration? Well, a quitclaim deed back, there is no consideration, which means the validity of the deed itself can be challenged. But then also too, it's an involuntary conveyance. The buyer didn't follow through. So you're going to take that quitclaim deed that you got and you're going to file it. That's an involuntary conveyance. They didn't willingly agree to it. And so you end up in court. How do you think that's going to go over in these courts here in Kansas City, where some poor tenant who may be economically challenged says they took my property, they equity stripped me. And that's actual term. There was a problem here 10, 15 years ago. People were selling under contract for deeds. Somebody would do something to get in default. They wouldn't let the buyer cure it. And the person who held the contract would come in and boot them out. They'd strip the equity because over time you've got equity in the property. And so the courts take a very dim view of that, very dim view.
And one thing that was mentioned at our meeting was you're going to be okay doing that if the borrower doesn't fight. But if the borrower does, which in this day and age with a KC tenants out there representing everybody for everything, they're going to fight and you're going to lose. And I believe that was about 10 years ago was when the state of Missouri and a lot of states across the country changed their laws saying you can't just evict a contract for deed tenant. You can't just file the quitclaim. You actually have to go through the full foreclosure process.
That is correct. And then you're at the whims of the courts.
So we've talked a little bit about drawbacks for the seller. Their drawback is in getting the house back is going to be really difficult because you don't have any rules around that. But what are some of the drawbacks for the buyer on buying on a contract for deed?
What if the seller dies and the deed got lost somewhere? Say the title agent goes out of business and the deeds are just gone. You know, how are they going to get their deed? And who's going to convey the property to them? So that's a huge one. The seller could get sued. They could go out and have a traffic accident and get sued, and that someone can get a judgment against them, and they can lose the house. But that holds true for both the seller and buyer, because you can attach a judgment against an equitable interest. Most don't, but you just never know that right is out there. And so that's some of the drawbacks for the buyer. Suppose the seller doesn't keep insurance policy in place. Suppose the seller doesn't make payments on the first deed on that loan that's out there. They use the term wrapped around, so to speak. I mean, all those things come up. They don't know all of a sudden they're booted out because that first deed of trust has priority.
So we got a question here. So the seller can refinance if there's no recorded memorandum clouding the title. So if the borrower is just go along making their payments and they think there's no other mortgage than what was there when they bought it. And some people do these contract for deeds and they just don't come to you, to the title company. They just do it at the kitchen table.
You are correct.
So they don't know all of the issues with the title. But Michelle is saying the seller could refinance if there's no recorded memorandum and get a huge mortgage against the property that they're never going to be able to pay off and they're not going to be able to sell it.
Well, that's where you get into, if there was no first mortgage that's being worked around, so to speak, and that contract for deed was the first financing interest or financing vehicle out there, then they have some different rights. They have an equitable right in the property. And if they go out and get a loan, say the seller refinances and takes a loan out, it's after an unrecorded contract for, the only people who are going to make any money are the lawyers, because if the contract for deed buyer has any kind of smarts, they're going to get a lawyer, and then it's going to be a dogfight. And the question is going to become, okay, there's no memorandum out there, so ergo the contract wasn't of record, so it's cut out. Well, but they're going to argue there's an equitable interest out there that wasn't dealt with, and we can't speak to that. I think one of the things that concerns me, Kim, is the fact that sometimes people oversell something and they say it's not a problem. They do their deal and they're gone. That can occur, yeah, but it creates problems down the road that somebody else has to try and clean up. And so I tell people, if you're going to do this, don't make any representations that you can't live up to. That's all.
I've found a lot of deals over the years where whoever had signed the paperwork didn't exist anymore, and we had to hire an attorney to solve the problem.
That's where you hope there's enough equity or perceived equity to property that to get it all fixed up and sell it. You can get your expenses back out of it.
So if I am closing a contract for deed, I don't really want to do that at the kitchen table. I do want to go to a title company. I do want to get a title policy on that, and they can get a title policy in a contract for deed sale, or can they not?
If you're selling on a contract for deed, you used to be able to get title policies ensuring somebody's rights to a contract for deed, but they've shied away from that. So my underwriters and I can't do it. There may be somebody else who will do it, but I can't do it anymore. I used to do it. I did it a few years ago. But here the winds have changed, so to speak, and they just don't want that kind of risk.
But you could do a title search just to let the person buying know what's on title right now. You wouldn't be able to insure the title, but they could see what you could find. So that's a report you can do.
You're absolutely correct. I would suggest just buying a letter report. That way they know what's out there and you've got something to look at. But here again, there's folks such as yourself and Michelle who are sophisticated enough. You know what you're getting into before you ever even sit down. You know?
Well, sometimes I don't know. So Jeremy is asking if I'm hiring an attorney to write that affidavit, or you said a memorandum to go with the paperwork. Do you record that memorandum, or if you don't record it, what do you do with it? Just hold it in a safe, or?
Well, no, you go ahead and file that memorandum of contract for deed, and that tells the whole world that there's an interest out there. And you tell them it's an unrecorded contract for deed by and between. And you file the legal description, and it's out there. When a title company does their search, they're going to pick up that memorandum, and that's going to tell the whole world there's an interest out there that has to be dealt with. And it'll be dealt with, has to be dealt with.
So if you were out there teaching new investors on these deals, would you advise them to use a contract for deed? I know every attorney I have talked to, I'm not saying you're an attorney, but every attorney I have talked to has told me, don't do a contract for deed, do a true seller finance. So what is your opinion?
I concur. Seller finance, if you can do it. But if you don't do that, sell it subject to the first that's out there. Make sure everybody is aware of the risk out there on a due on sale provision, but just do it straight for that way they own it. As the owner, your liability is gone. You know, the only thing you're really worried about is keeping the insurance in place, which you are, and make sure they don't trash it real bad. If something goes bad, you know, with 30-day notice, you can make the demand, and that you don't have to use a lawyer to do a foreclosure. I've done foreclosures. There's other folks in town who do foreclosures. A foreclosure, 30-day demand, you know, or if you're servicing the loan through somebody else, your servicer can start that process and then hire somebody to do the foreclosure. 22 days later, you own the property. It's clean and straightforward.
I can't speak to the price of a foreclosure right now, but I beat Michelle out of two non-performing notes in Kansas City, Missouri. I foreclosed on both of them, and I think it cost me less than $2,000 a house.
Yes.
And it was 3-4 months at max. Of course, I wasn't taking the house back. I sold it at the courthouse steps. I'm a weird bank foreclosure person. I advertised the courthouse sale and put pictures out there so every investor knew what the house looked like. So they'd all go bid on it and bid it up. And I made my money on the courthouse steps, and it was awesome. So
that's a unique way of doing it, Kim. Good for you. But the process is the same. You send your demand letter out. They don't cure the default. Start publication. 21 days later, someone's at the courthouse steps crying to sale. And you've all bought stuff that, you know, somebody's standing there holding a piece of paper, mumbling to himself. Just be sure and know what you're buying.
yes.
Don't buy a second.
Hey, you never know. All my seconds have made me good money. So,
Okay.
but I bought them for tiny pennies on the dollar. So there's a difference.
There you go.
Have we answered all the contract for deed questions? Did we get all of the big high points, Michelle, that we were supposed to?
I think so.
Okay. Well, I want to thank everybody for joining us. I want to thank you, Bud. How do we reach you? If we need your help on a transaction, how do we reach you?
You can always give me a call at 816-536-4761. That's my direct number, or you can email me at bud.whisler@advantagetitleLLC.com.
Okay, and you're also on the Mary website. So if you go to mary.org and click on the business directory, his contact information is there.
Well, I just want to leave one last thought, and I appreciate you giving me the opportunity to share it, to talk with you all. And that is, if you don't know what you're doing, if you're not as sophisticated and haven't been doing it for a while, ask questions. The only dumb question is the unasked question, because our goal in life, my goal in life anyway, is to keep you guys from getting jammed up and having something jump up and bite you down the road. Because if it bites you down the road, it's usually going to cost somebody a whole bunch of money. And so I'm here. I don't mind asking questions. I'll oftentimes ask, do you want the answer? Do you want to know the history behind it? Sometimes I'll get, just give me the answer. Or sometimes, yeah, I got my coffee. Let's go. And so.
Yeah. And I can highly attest that if you're new or you have something really weird, reaching out to our title people like Bud is one of the best things you can do, because they can look at the problem, no matter what it is. They've probably solved it, and they can educate you. And I'm going to say, I didn't grow up at the knee of Bud as a real estate investor. I had a different title person I worked with back 15 years ago. But everything I learned about all these weird issues that I deal with, I was hand-led through the path by my title person. So reach out to your title people. They're way cheaper than the attorney, and they can tell you the real world application on how it's going to work. They might advise you to seek out an attorney to make sure they got, they can't practice law unless they are an attorney, but they can usually answer your question quite well, even though they can't practice law. Does that make sense?
Absolutely.
All right. Okay, well, I think we've got all of our questions answered. I want to thank you again for joining us. I want to thank Michelle for her assistance, and everybody on the call that's watching and listening in. Thank you for being here and learning things with us.
Thank you much.
All right. Well, I'm going to end it for now.